Good morning.
Good morning. I think I was in the wrong link.
Happens to the best of us. I always say now with Zoom, if you don't have to say at least once, you're not mute, you're muted. Or if you don't go to the wrong Zoom room and then have to figure out where you're supposed to be, I don't think it's really a hearing. So you're
As
in
I said, nobody's
fine
here. This doesn't seem right.
company.
Good morning, Your Honor.
Good morning, Mr. Brogdon. How are you?
I'm well, and yourself?
I'm doing well, thank you. Um,
Shockley.
so we are here today for a pretrial conference in the matter of Katara Flakes versus MARTA. Can y'all, before we get into the details of it, any chance y'all have updates to tell me about in terms of y'all resolve the case and, no big deal?
Your Honor, Judge, I would be honest with you. Much to our demise and displeasure, the case was not resolved.
Okay.
Again, I only have the authority of my client, and I would like to get this resolved, but unfortunately, I'm going to have to try this case.
Okay.
Uh, and so it won't be much to be tried.
Okay.
The only issue that I think is outside of the nuts and bolts of our consolidated pretrial order and motions in limine, if we have any, is my client is in Cincinnati and
Okay.
so have to come here for trial. So this upcoming trial calendar, if we could be placed on the next one, so I could get her arrangements to get down here for trial, that
Okay.
would be best. That's really the only concern that we have.
Okay. What are your thoughts, Ms. Shockley, on that issue?
We have no objection to that.
Okay. So I feel like we're probably pretty open in terms of our ability to schedule things, and here's why. You guys never submitted a CPTO.
That's
Uh,
what I was double checking.
right. And so, so my notice that I send out in conjunction with my standing orders, it says that if you don't file a CPTO, then you have affirmatively waived your right to a jury trial. So that's a good thing in the sense that what that means is that we can schedule this case kind of whenever we want to. That works for everybody, particularly if you tell me what the announcement is time-wise in terms of how long you think it would take to try, because of course we're saving ourselves at least half a day, sometimes a whole day, trying to select a jury if we know it's going to be a bench trial. The other thing now, your client may very well still want to be here for that sort of proverbial day in court, but if you're not worried about a jury, thinking that she's not invested in her case because she's not here, y'all can talk about it because y'all would need to consent, but like parties can attend by Zoom. I mean, we would probably do the trial itself in person because I find that it is remarkably less complicated than doing it on Zoom because, it seems nice to sit in your office. But at the end of the day, what ends up happening is it gets clunky trying to present evidence and, that sort of thing. And so it would be an in-person trial, but because we would be doing it sort of at our own agreed availability, we could do, we could work around a lot of things when we don't have to worry about a jury and perceptions that a jury might have for different reasons. So,
Right.
so that's kind of where we are. Mr. Freehoff, I know our next calendar is the 23rd, but we had looked at moving it to accommodate what do you call it? A bench trial. Is that right?
Yes. 23rd, there were only two matters, and the one has resolved now due to the failure of the defendant to file an answer, which got struck, and then default judgment was entered. So this case is the only case scheduled for the 23rd.
Okay. So I am aware that I'm supposed to potentially start a criminal trial, which may very well push that April 23rd. So I don't mind moving it from the 23rd. Ms. Shockley, what are your thoughts about that if we were to schedule it for some time in the near future, just not on April the 23rd?
I guess, do you mean before the 23rd? Is that what you're
No, no,
saying?
no, no, no. No, I would be pushing it back a little bit. So one, we could all agree on when it would be. And two, so Mr. Brogdon, should his client choose to attend in person, would be able to make those arrangements and be here. So what are your thoughts?
Um, I could do after the 23rd. I do have potential conflicts the first week in April through the 6th through the 10th. I'm on 3 other child calendars that week.
You mean May?
Yes, in May.
Okay, yeah. Okay.
But I see a couple of those will probably be resolved
Okay.
by then.
Okay. How long do you think, Mr. Brogdon, that you would take you to try the case? Well, I mean, 2-3 days, or what are you thinking?
No, Your Honor. This case will be put up and put down.
Okay.
We wanted it resolved.
Okay. So like a day?
Yes, Your Honor. This is a bench trial. We don't have a jury selection, so I believe this evidence can be put up in a day.
Okay. Does that sound reasonable, Ms. Shockley?
Yeah. Well,
Let's do 2 just
to err on the side of caution,
Right.
I would probably
I
say
always allow a little bit of spillover, right? Because, you know, even when a jury's not here, right, it's always better to, under promise and over deliver, right? So even if it only takes us a day, then that's an extra day on my calendar and yours, right? That you can take care of other things you didn't think you were going to be able to get to. If it does take that second day, then we'll know we have it set aside. I need to look at my calendar to figure out what I've got going on. Mr. Brogdon, when you were suggesting that we push it from the 23rd to allow some of that travel time, did you have a specific time frame in mind?
No, Your Honor. And the reason for that was I was going to see what when your next trial calendar was, because my client, I have a call with her after this.
Okay.
To explain to her what went on at the pretrial conference because she wants this case to be tried. So I was really going to be definitely at the mercy of the court, but hopefully seeing what trial calendar would be next that we could be on. So we can start getting her arrangements together. Okay.
Well, let me pull up my calendar and see what I'm looking at.
Excuse me, Judge Cross.
Yes, ma'am.
Just a question in the meantime. So should we not submit a PTO at all now because we're doing this, or I imagine it might still be helpful.
I was going to say, I mean, I find them still helpful because I think it helps people sort of resolve, or not resolve,
narrow the issues,
identify the issues and narrow them for what we're really going to do. But it doesn't have to be in that specific format. I mean, it really is more like, you know, who are the witnesses? What are the documents? And, you know, that sort of thing. I don't need you to give me a list of your theories of recovery or the nature of MARTA's defenses. I'll figure that out from the complaint and the answer and what you guys say at the trial. But stuff, you know, some of the basics of a CPTO, I do think it would be helpful to have that. So to the extent that y'all can agree and, you know, present something like that, or if y'all can't agree and choose to present something else, that will be fine.
I think we can agree. I don't think it's going to be very difficult. Okay.
So the original trial calendar was the week of the 23rd. Now, the week of the 29th of April, which goes into May 1st, 2nd, 3rd, those are somewhat open for me. In particular, the week of like May the 2nd into the 3rd, which we would start, like, for example, we would start the trial on a Thursday and then we would have the 3rd to spill over to if we needed it. I don't think other than a judge's meeting that I would need to take a break for lunch for, that is about it. And for those days, those would definitely be good days if we could make those work. Does anybody have a leave for those weeks or conflict or anything? Or for those 2 days?
Yes, Your Honor. I'm fine on those 2 days. I have a deposition that will be moved. I can move that. And we should be fine for those days. I'll make sure that my client can be here.
Okay. Ms. Shockley, what about your calendar?
That's what I'm double checking now.
Sure.
I do not have leave out for those days. It's at the end of May. So yeah, I'm okay for, we're saying May 2nd and 3rd.
Yes, May 2nd would be the start and May 3rd would be the spillover day.
Okay.
And if it would be better for anybody for any reason, I can tell you that if I could start the trial in the afternoon of Wednesday, May the 1st. I have drug court in the morning. But we could also do an afternoon start time at like 1 p.m. on May the 1st and then spill over into that Thursday. But those days would be the best days. And so whatever days we agree on, what I'm going to do is have Mr. Freehoff just issue a very brief, it won't be as quite as comprehensive as the one we typically issue, but it would just be, you know, a very brief notice so that it would be on everybody's calendar and you guys would know that we were going to do a bench trial on whatever days, probably May the 2nd and 3rd, starting at 9 o'clock on whatever day we start, or if we start on the 1st, it would be starting at 1 p.m. What do you guys think?
Your Honor, I'm perfectly fine with starting it on the 2nd at 9 o'clock, and I would propose that if Ms. Shockley would be open to it, we could get you that pretrial order
Okay.
by next Friday, so we
Okay.
have enough time to get everything and make sure you're aware of the issues and
That sounds great.
witnesses that'll be available.
And especially, I will tell you, especially because it's a bench trial, look, you guys need to preserve your record. And so if, you know, there are objections that need to be made, that's totally fine. But especially as to exhibits, you know, to the extent I used to practice in federal court where, you know, the judge basically made you agree on all the documents except the ones you really, you know, were going to take issue with. And so to the extent that the parties can agree so that we can waive the, you know, extra time that is occasioned by each lawyer for each document having to ask 3 questions to get it admitted through the witness. You know, if we all know they're coming in, then maybe we can dispense with those things. If y'all aren't comfortable with that, or if there's some reason that you can't do it for your client, I certainly understand. But just a suggestion when y'all are looking at the putting together the pretrial order with the exhibit lists and stuff. So what we will do is notice the trial for 9 a.m. on Thursday, May the 2nd. And then my next question to you guys is, are there any, I know you guys are going to put together a pretrial packet of some sort. And, you know, we can talk about, because there won't be a jury there that we're worried about being delayed, we can talk about pretrial issues that arise at the time that we show up for trial. But are there any other pretrial matters, any things that you wanted the court to address while we were together today?
None that I can think of, Your Honor.
Me neither.
Okay. So last question I have is, I don't necessarily want you to tell me where the breakdown was in mediation, but is that really just sort of a done deal? Like really not hopeful, as Mr. Brogdon said, he's going to have to try the case, or is there still some wiggle room? Like, you know, I mean, I know lawyers always say, nope, this is it. There's really never going to be a settlement. And then sometimes there is, but I'm just curious.
Your Honor, I try a lot of cases, and I know the ones that need to be tried, and the ones that
Yes,
need to be
sir.
settled. This is a case that needs to be settled, and my client is not giving me authority, and she will not give me authority. So unfortunately, the breakdown happened. Ms. Shockley and I worked really hard at mediation to try to get it done.
Mm-hmm.
She did as best as she could. I did as best as I could, but ultimately, there was
Well, we can only do what our clients will allow us to do, right? I mean, at the end of the day, that's your job, is to serve your client's interests and counsel her wisely, and then it's her decision to make. So that's the best you can do. Okay, so then I will look forward to seeing all of you on May the 2nd at 9 a.m. Obviously, I will look forward to whatever you guys want to submit. If you need anything from me, let me know. A couple things to let you know about trying a case in my courtroom, even without the jury. We use Zoom to display evidence. Now it matters a little less when you're, you know, not in front of a jury, but still, to the extent that you're going to want to, you know, put up a document on the screen so that I can see it, you know, those sorts of things, what will happen is we will issue a Zoom link for the trial, and then you guys can have it and log in with your own computers. You'll have their screens throughout the courtroom. And if you want to share your screen and show a document, you can do that. My experience, though, is that if you need the witness on the witness stand to identify the document before it's published, you know, to me, then you're going to want to have, you know, a notebook or some paper copy of those documents to give to the witness to have them identify the documents. But if we're waiving a lot of that, then we can dispense with a lot of that. But I'm not saying you have to. I'm just saying you should consider it. And then the only other thing I will remind you is that I do not provide a court reporter, because the judges, I don't currently have a court reporter right now. Hopefully I will have one by May the 2nd, but they're only taking down criminal right now because the volume of the criminal cases is so significant. So to the extent that you guys agree that you want the matter taken down, you're going to need, and my orders do say that, my standing case management order, but you're going to need to make arrangements for your own court reporter. So I just remind you that, because sometimes people just assume that we have court reporters and then there's a scramble right when everybody gets here to find a court reporter. And I don't want y'all to have that experience. So anything else that I can answer? Any other questions, issues?
No, Your Honor.
Okay.
None for me.
Okay, excellent. Well, Mr. Freehoff will send out a notice for May the 2nd and 3rd for the trial of this matter, and I will look forward to seeing